Okay, so yeah, let's see for Viva. So I'm just giving you all highlights what happened in Viva, how they ask questions, and how you have to prepare yourself for the Viva. So I'm sharing my screen as well as I will keep on interacting with you all so that you can prepare yourself for the Viva. So as you all know, your clearance of patent agent exam depends on sum of all the paper 1, paper 2 and Viva, all the three. So you have to just score the passing marks in paper 1 and 2, and total passing marks will be dependent on how well you scored in Viva also. So suppose for 50 marks of Viva, if you are scoring more than 45 or more than 40, then there is a strong chance that even if there is some you couldn't score well in paper 2 or paper 1, then even then you can clear the exams. So Viva is a last stop where you can really put your best efforts so that your total marks will be more than the qualifying marks, and you can qualify even when something has happened and you couldn't answer in paper 1 or paper 2. So still you have many hopes, like if you do very well in Viva, you can definitely clear the exam. So I wish to tell you my own experience as well as the other people's experience that normally happen in Viva. So on the day of, like, whenever the results will be declared, so along with that you will get the date of your Viva. And normally Vivas are being conducted in Indian Patent Office. So in your jurisdiction, normally you are being called. So suppose if you belong to in the Maharashtra region like Gujarat or Rajasthan, you will be called to Mumbai Patent Office. If you belong to near to Delhi, you will be called in Delhi Patent Office. So every patent office conduct the Viva. And these Vivas are being conducted by the patent examiners and controllers. So there is a team of about 2-3 people consisting of examiner of patents, and one controller could also be there. So it depends. But so what happened, whenever you will get a date of your Viva, then you have to start preparing. But I suggest that you start preparing from today itself, or I think you might have started preparing it just after your paper 1 and paper 2. So how to exactly prepare? uh, Things are very unpredictable. Actually, whenever you reach for to the Indian Patent Office, you have to reach at least 1 hour earlier to the time of Viva. You will be said to wait in a waiting hall just after arrival. They will verify that you are present. Some people will come from inside and they will ask your name. They will verify that you have really reached here, and now you are in the queue for the interview or the Viva. So you will be in the waiting hall, and you have to wait like about half an hour to 1 hour. This is the normal waiting time, I'm telling you. So during this time period, you can discuss with people or those who are coming out of the interview hall. You can have a small discussion with them. So normally waiting time is more, so carry something to eat, to drink, relax, just talk with your peers, and try to just revise something. So what to revise for the Viva, that is important. And keep yourself very very cool and calm. Dress well, this is very important. Like normally a patent agent, like a lawyer, if you are dressing in a good blazer and a proper formal attire, this has a real effect. So a good appearance, good attire is very important for interview. Keep yourself very cool and calm, very formal, and like have enough food in the morning, because you will be, I think sometime it happens that you have to wait till afternoon. So you have to keep yourself hydrated, energized, cool and calm. First of all, this is very important, because how do you respond depends on how do you feel. So this is all about. Now I'm coming to the technical points, what exactly should be there. So for Viva, there are something which are very predictable things. So I'm sharing my screen to you, and I'm telling you some very important parts, very important technical things that normally controllers ask. I wish to let you know that normally every section, every subsection is not, if you don't remember, do not worry about it. Never take too much time, because I just frankly speaking, there is a real grilling screwing, even if you are a very learned, even if you are a very have everything in your in your mind and every answer you know, sometimes it happens that they grill you in such a way that sometimes you forget. So I am again repeating, you have to be very cool and calm, understand, listen properly to their questions, then just think for a while, do not be in haste, and answer calmly. Even if you don't remember the section, never be impatient. Just remember what they need to ask. You can even apply some common sense in answering their questions, because normally nobody can remember all the subsection and can instantly answer, because everybody takes time. Normally taking too much time in answering is not so good. So it is better that you just apply your knowledge, whatever you have studied, in answering their questions. Never think that I don't remember the section or subsection, that's why I'm not able to answer. Never think like that. You have to be just answering their questions. So I'm just sharing some presentations what they usually ask. So one by one we will see that.
Yes.
So for Viva, exactly how to prepare. First of all, your first question normally is, what is your background? Tell us more about yourself. So just prepare an answer about your basic details. Do not be very lengthy. Just mention what is very important, like what course you did. Like if you have done doctorate, definitely mention that. If you have a good qualification, they are really impressed with all those things, so tell it. Do not be too long, but tell the basic qualification. Your professional experience, you must tell, not only related to patent. Even if you are a good researcher, good innovator, tell them. It just 3 4 sentences. Do not give unnecessary detail, much about accolade, much about prizes or all those things. They are not very concerned. Tell very concrete like research, innovation, or patents if you have filed earlier. If you are an academician, tell them, yes, being in academics, I have done some research and I have filed the patent for that, and I have did till the publication or examination. All these things you can definitely tell them, but do not mention anything that is not necessary. So just prepare this answer well about yourself. This should be complete within 1 to 1.5 minutes maximum. Then another question they will ask you, definitely, why do you want to become a patent agent? They have asked me also this question. So prepare a very honest reply. If you are in academics, normally my answer was there, because being in academics, I do research, my students are doing research. I support startups, because being the in the domain of startup and entrepreneurship, sorry, so I do that. Then whenever I feel difficulty because I don't know how to prosecute the patents, and I have to contact many of the patent agents, patent attorneys, and that's why I'm not very aware. Even I'm not aware that patent is abundant if we do not file the complete specification within 12 months. So this is the way actually we should be having a good awareness. And being in academics, it is very necessary to be aware, because being a mentor, if I don't know how to prosecute a patent, how I can proceed with my students. So this is a very mandatory thing. So this was my answer. If you are a patent professional, very honestly say them that I'm a patent professional and I wish to file the patents for all the innovators who did lot of work, but they don't know how to file a patent, and because of that they are suffering. Sometimes they publish it, they don't file patent, and they are underprivileged. Being innovator, they sometimes don't know how to commercialize their product. So patent is for commercialization, prosperity, for you can just mention for contribution in the Atmanirbhar Bharat mission. So all these things are there, but yes, do not emphasize much on that. You also say that this is my profession, I want to have a mastery on that, so that I can, along with contribution to the nation, I can also earn for me and can support myself. So this is also a reason that I want to become a patent agent. And patent agent has all the rights to like present their clients, their innovators before the patent office. And yes, like there much knowledge to be acquired, much practice is needed, but I'm hopefully I will do that. So in that way you can like justify it very effectively. Also remember, do not make very lengthy answers. Complete it within 1 minute maximum. If they are ready to listen, definitely you can carry on. Read their expressions, look at them in their eyes, try to read their expression. What are means like what are they preferring, what they are not preferring. Just try to read it out, and accordingly you can adjust your answers also, because sometimes some controllers do not want to listen much. You can wind it up. So read their expressions perfectly while answering the questions. Also, what is the procedure for filing a patent? Normally they ask, because if you are going to become a patent agent, so I think everybody knows now what is the procedure. Form 1, form 2, form 3. This is the normal procedure. And then a question was asked from me is like, whenever you file patent for your students, then who is the innovator? They have asked me. So who is the innovator? Who is the applicant? They have all asked. So my answer was that all the innovators and applicants are the same in our case. Why? Because students are innovators also, and on the patent certificate, the name of applicant only appear. That's why we prefer that all the innovators' name must be on the certificate. That's why we keep all the innovators same as the applicant. Then they asked me, if suppose innovators are not the applicant, an applicant is somebody else, the sponsoring body, then what will you do? Then I said that we have to fill the form 5, and applicant should declare that these are the true and first innovator. So that time I mentioned that form 5. So if you remember the forms, definitely mention in your answer. They will be impressed that you remember the forms. And I said that there is no fee of that. So whenever fees are there, you have to mention the fees also. And if fees are not there, mention the forms. So in this way, you have to answer those things. Now they asked me again one more thing. You are taking the help of your university resources. Now university has an objection. They are saying that you have taken my resources, but my name is not there. So how will you include your university as an applicant? So definitely there are clauses. Even substitution of applicant is there in the section 20. So applicant could be substituted. So university could become an applicant, and innovators could be students and mentors. So in this way, you have to write it. Again, they have said me, suppose university says that assign the rights to me. So another there is a clause like a patent assignment. Assignment can be done. So if you don't remember the section, don't worry. Just said that in patent laws, there is a provision that patent could be assigned to somebody, and assignee will be the holder of the patent. So in this way, you have to carry out. So always remember, if you are an academician, always remember what are the academic constraints, what are the academic clauses that would be applied, because they normally do not go to another domain. They will go in your domain. If you say that I'm an industry person and I want to be a patent agent, they will definitely ask what are the fees for industry. If you are saying I'm a startup, then they will ask you definitely what are the benefits for a startup in Indian Patent Act. So they will go inside your own domain. So always remember, there are some applicable causes that fit in your own domain. Suppose in academics, the domain are substitution of applicant, assignee, inventor, who is the applicant, who is the inventor. So these things are there. Then proof of right application is also very important. Whenever we are innovators have to be justified that this is the rights belong to this person. So it normally happen. So just take an idea, like if I'm an industry person, if I'm a startup, if I'm a simple professional, just want to be a patent agent, then they will definitely ask you all the questions related to your clients. A client approaches you with a herbal product, what will you suggest? A client is coming with a product that is already displayed earlier in public domain, what will you suggest? Then they will say 3 clients have dispute. One is saying that my name should be added. So can it be added or not later on? So as a patent agent, all questions will be related to client dispute. Suppose like wrongful obtainment. This is the case that they will ask you as a patent agent. Somebody has taken it through wrongful obtainment. What remedies are there? Somebody is yeah, for patent agent, infringement will be a major cause, and pre and post grant opposition, they will definitely ask you questions like as a professional patent agent, they will ask what are the grounds on which pre and post grant opposition can be done. Then what is infringement, and what are the cases in which infringement is not considered to be valid, means it is considered to be not infringing. So they will ask these questions. So these are already being covered in the sessions. Just you have to focus exactly. So they will just see that in which profession you are going, are you able to apply this qualification in that profession or not. So for patent agent, all questions will be about infringement, pre-post grant opposition, disputes among two applicants, inventor-applicant disputes. So all this dispute solving capability, do you possess or not? This is the major evaluation criteria for a patent agent. So you have to definitely go for all the dispute related and litigation related. And patent filing, how to file a patent, definitely you must know each and everything, all the processes, forms, especially form 9, form 18A, this should be totally in your mind. Okay. Then questions on pre and post grant oppositions are very common. Normally they ask. Then there's questions on compulsory licensing. Working of patent and compulsory licensing, they will definitely ask, especially for like anyone. They will say that your client, you has helped your client in getting the patent. So they will ask you that you have helped your client in getting your patent, getting his or her patent granted. So now what is the working statement? Like working of patent statement, which form has to be filled? Form 27. Then suppose your client couldn't prepare the product well. Suppose this is the section 84 of the Indian Patent Act, which elaborate the grounds for compulsory licensing, means reasonable requirement of the public not satisfied, patented invention is not available to the public at affordable price, and patented invention is not used in territory of India. So at these three grounds, anybody can claim for compulsory licensing. Normally companies ask from such company who is not fulfilling such requirement. On denial, they can approach the patent office, and patent office can direct this first company to give the compulsory license to another company. Then they will ask you, give any example of Indian patent case which is a landmark case in case of compulsory licensing. So you should remember Bayer versus Natco. So Bayer versus Natco case was a landmark case where this compulsory licensing was intervened by the patent office and given from one company to another. So definitely go for the cases. They will ask you Novartis versus Union of India, that I have explained you in the lectures. You prepare that. Then Bayer versus Natco, Roche versus Cipla. Roche versus Cipla case is also very important. So these landmark cases that we had discussed earlier, that you have to specially prepare. Bayer versus Natco case. Then TVS versus Bajaj bike case, that was also a landmark case. So TVS versus Bajaj, then Apple versus Samsung. So these are the cases which are very landmark cases. Then they will ask you what is section 92. So 92 section says that especially for in the case of national emergency, extreme emergency, or public non-commercial uses, government may take up the product. There is no waiting period for compulsory license. License would be given to anybody because products should be manufactured in large quantity. Why in large quantity? To meet the public demand. Because this is a national emergency. Because this is extreme emergency, nobody can take a patent on that. It should be like given to other companies also, so that they also can prepare, and together all companies should fulfill the demand of the public. So this section 92 is a exception. So whenever you say that this section 84 says about compulsory license, they will say you what are the exception in which this is not valid. So section 92. So these are some questions which are normally very important. So you prepare specially for working of patent, compulsory license. So in this way, like you can suggest your client. So these are some things. Then in my interview, they have asked me, luckily, what is the procedure of patent cooperation treaty? And if suppose you are getting this question, you have enough to say, because you may forget sometime the section in front of them, sometime things. But yeah, I scored well. Why? Because I even that time some sections I might have forgot, I don't remember, but I answered every question. You keep on speaking, never keep quiet, never become like try, just try and try to speak. You keep on speaking till the last of the interview. They have, like, your interviewers must say you to go, you shouldn't stay quiet. Whatever question come, you try to answer, you struggle for it, fight for it, and try to answer as much as possible, try to solve it, like you're fighting in a court for your client. Like this you have to behave, because sometimes they will throw you question one by one, and they will try to grill you even if you are very best. So you might feel that I'm being grilled or I'm being screwed, but never lose your calm. Keep firm and try to answer, keep on speaking till the last. This is the major thing I want to tell you, because I did it. So and luckily I got this PCT question. So you have to explain everything about PCT, starting from 0 month to 30 months, every step. If you are explaining them that, like, a 0 month application is filed, uh, got the priority date, then at the end of 12 months international application has been filed at the site of WIPO or the own receiving office. If certain patent office are also receiving offices, like India is also a receiving office. Then at 16, transmittal of Indian international search report comes, and written opinion. Then at 18 months, publication of international application ISR and written submission. Then at 22 months, applicant can demand for, this is optional, international preliminary examination. And at 28 months, this come transmittal of all these things come. At the end of 30 months, they can enter the national phase. In India, this is 31 months. So you have to exactly explain like this: first invention, first application, then this is international application. And always remember, this is your first international application. So your priority date will be counted from international application, because international application is a complete specification always. It can never be provisional. So from a complete specification only, a PCT priority date is calculated. So that's why this is your priority date for international processing. So in this way, if just remember this diagram and try to answer their questions. So if you can just give them timeline and what happened at which month, at least in broad, this question will be solved. So normally they ask PCT, and yes, you have to say something like, because India in year, I think 2019, India has received maximum PCT application, because India and like released maximum search reports, because in India the fees are less. Even the foreign applicants choose India as the searching authority. So I have mentioned during this my answer that I'm also proud to share that Indian Patent Office is considered as the largest searching authority, and this year maximum applications have been like maximum applicants have chosen India as the search authority, and Indian Patent Office released maximum search report. So such kind of things, if you are mentioning in your answer relating some current affairs, because while you can even Google out what are the recent things going on in patents. So this time something in news it has come. So I mentioned that, and they become very happy after listening to all those things. So such things you have to keep in your mind. Then the question, these things are important. This table actually I had explained you during my session, so at least you can remember what is the application for grant of patent: form 1, form 2 provisional, form 3 statement and undertaking under section 8 for foreign filing. So these things, if you can remember, it will be really impressive. because if somebody is mentioning the form number, it is good. They try to find out whether you remember the form numbers or not. Fees are okay, but at least you should have an idea. Like if you are a startup, how much reduction you are obtaining, that is 80% reduction. If you are an educational organization, so educational organizations are also availing 80% reduction from year 2021. That was the recent amendment. So this thing you have to remember. So just remember form number. If you can remember some section, subsection, that is fine. So in this way, form, some important forms: form 9, request for publication; form 10, application for amendment; 12, request for grant of patent. Then these forms are important, form these are all about working, non-working, and compulsory licenses. So form 17, this is very important, application for compulsory license. Right. Then all are related to compulsory license, like application for revocation, for patent for not working, like this. Form 27 is very important. Every grantee has to submit a statement regarding the working of the patented invention or commercial scale in India. And 3 grounds you have to remember. Form 26, this is power of authority, because this must be there. So, and then again, some questions like this: one has filed, another don't know how to explain the patent office. So, simple thing is like it has been given as a wrongful obtainment. So exactly how you can help your clients. Startups, they will definitely ask, because this is the era of startups. So they will, this would be a question you can speculate, is like, what rights provided for startup and small entities under the patent rules. So they can avail the benefit of expedited examination at 80% reduced fees. And also in the filing, publication, everywhere they are availing the discount. And yes, women applicants are also can avail such kind of facility of expedited examination as per rule 24C. So for startups, women entity, natural persons, the fees for expedited examination is just 8,000, whereas for industries this is 60,000. So it's a large benefit. So monetary benefit definitely should be mentioned in your answers. Features in patent amendment. 2005 amendment, normally they do not ask, because already these things are very common now. But yes, you should understand that compulsory license, this was included in 2005. Actually 2005 was a landmark year in which everything in patent was included. So compulsory license included, product patent was included, then pre and post grant oppositions, both were there now. Pre-grant opposition was also included. Mailbox provision removed. Timelines flexibility has been incorporated. Many things are there. Parallel imports. All these things are in 2005. What are the section 2? What is inventive step? What is new inventions? All have been included. Then section 3. Section 3D. This is very important. Section 3D was included in amendment 2005. So from 2005, a large boom in the R&D sector in pharma industry took place, because now nobody can launch the same drug by just changing the salt form or polymorphs or isomers. They have to actually do the real innovation before launching any drug in the market. So that's why this 3D is a major breakthrough in the Patent Act, especially for the chemical industry and pharma industry. Then pre-grant opposition was strengthened. It was included. Extension of time for filing pre-grant opposition was included. And this is really helping the patent office, because it can be filed by anyone, need not to be an interested person. So if many people find out some loopholes, it will really help the patent office in examining the patent application. But post-grant opposition, normally they do not give rights to anybody. They give it only to interested person, because there are a lot of time and monetary expenses has been done during the prosecution. And even patent office do not want that after grant, post-grant opposition should come and patent then again should be revoked. This is normally not a desirable thing. That's why. Then pharmaceutical export to list developed countries, section 92A was included in compulsory license. So whenever there is a emergency or some country doesn't have facility. So in that case, there is exemption for compulsory license, that is section 92A. Then transitional arrangements are there. So these are, I'm not telling you each and everything because these are not so important. Yeah, from here you have to focus exactly from 2019 to 2021. These are the years of amendments. And all the amendments, any amendment they can ask you in Viva. This is very sure. So Patent Amendment Rules 2019, this is the amendment. Electronic submission of records made valid. Means you can electronically submit the records. Original document can be submitted within a period of 15 days if asked. And for small entity and startup, every document for which a fee has been specified shall be accompanied by Form 28. So these things have been mentioned. Now, this is a very important part. Applicants who are eligible to file request for expedited examination. So, applicant must be a startup, small entity, or natural person. In the case of joint applicant, all the applicants are natural person, then applicant or at least one of the applicant is a female. So in that case, they can avail the benefit of expedited examination under Rule 24C at a discounted price, 80% reduction. So just 8,000 rupees was there, and Form 18A is applicable. So this is a very important question for you. Patent Amendment Rules 2019. This has been asked to me. What benefit you are expecting as per the latest amended rules 2019? So I just said that being a female applicant, I will avail the same benefit as a startup. As per Rule 24C, I can file Form 18A at a discounted fee. So these are some more. Then applicant, Department of Government, normally it's not so important. Institution established by government company. Applicant is an institution pertaining to a sector notified by central government, so all government premises. So this was not very important from our like from question point of view, but you can remember all government organizations. Fee schedule. Official fee for transmittal of ePCT and preparation of certified copy has been removed. So transmittal fee is not valid in PCT now, whenever it is filed through e-filing mode. So that was a major, you can say that discount in PCT filing. Also, they will ask that what discount India can avail in PCT filing. So there is a 90% fee reduction because India comes under developing nations. So WIPO offers 90% reduction in fee in all things. There is no transmittal fee. Already it is removed through e-filing, as well as for filing the international application fee is there. Then search fee. All these things here, it is 90% discounted price. Means like natural persons have to pay. So this is again a major benefit. You have to remember that. Because now patent office is also very much focused about PCT applications. So prepare PCT well. Now Patent Amendment Rules 2020. So this was totally based on filing of Form 27. So Form 27 is about working of patents. So now many things have been given. Basically, it is about flexibility in filing the Form 27. So patentee would get flexibility to file a single Form 27 in respect of single or multiple related patents. So they can file a single Form 27. No need to file separate. So if their patents are, suppose Tata Nano car, it is protected by 200 patents. So they have to just file one Form 27 for single or multiply related patents. So these are a kind of benefit provided. Patent is granted to two or more persons. Such person may file a joint Form 27. So these are some of the benefit. Authorized agent would be able to submit Form 27 on behalf of patentee. This is a very important question for answer for you, because they will say that how will you help your client in filing the Form 27 as an agent. So you have to say that I can file on his behalf as per the recent amendment in the rules 2020. Patentee will not be required to file Form 27 in respect of part or fraction or the financial year. Yeah, so some part or fraction is remaining, they don't need to file. So these are all flexibility and all kind of support that government provided. So these are all about tribunal. You don't need to remember much, but it's okay. Patent Amendment Rules 2021. So this is specially for academics, university, established or incorporated by or under Central Act, Provincial Act, State Act, or include any other educational institution recognized as by an authority designated by the central government or by state government or the union territories in this regard. So normally universities comes under central government or state government or any educational organizations. So they can avail the same benefit as the natural person, startup or small entities. They will considered as an applicant. So nowadays all organizations are becoming applicants because it is the same as the natural person. They have to pay the same kind of fee. So this was a major breakthrough, especially for this. So 80% rebate on patent filing. This has happened on 23rd September 2021. Rebate on patent filing for educational institutions. So this was a major breakthrough in that. Okay. So if you answer the questions, try to answer in that way that Ministry of Department of Promotion of Industry and Internal Trade, as per notification in the Patent Amendment Rules 2021, suggested that universities can avail such benefits. So in this way, your answer will have some weight. So everybody knows that DIPP takes such resolution. So why not to mention such things in the answer? Some recent patent cases they will ask from you. So some recent patent cases are Merck, Sharp, and Dome Corp, and YMS Laboratories Private Limited. So this is about sitagliptin and its derivative salts. It was an infringement suit against the defendant. Plaintiff prayed for interim injunction. During the pendency of the suit, after reviewing the facts presented, the court granted an ex parte interim injunction as the plaintiff made out a prima facie case. So interim injunction was allowed. Plaintiff in this case submitted evidence to show that defendant was planning to launch an infringing product under the brand Stalep M, which enabled to get the ex parte injection. So very simple. It was sitagliptin, and it was an infringement suit, and interim injection was applied. So don't need to like narrate the full paragraph. At least if you can remember something, like yes, what I remember is about sitagliptin, and this was the decision of the court and interim injection, and this was an infringement suit. So in this way, your answer could be managed. These are all 2021 cases, so that's why it may be asked. Even you can like Google it out, some recent patent cases of 2022, but normally they will ask for 2021. Then FMC Corporation versus Natco Pharma. This was for the product chlorantraniliprole, CTPR, an insecticide, and patent were species patents that it was claimed in the Marcus claim of expired patent. So you have to say that it was about a Marcus claim. The compound was this. Many species were together claimed. So what is a Marcus claim? They can ask you. So I'm just giving a basic example. If I'm just telling you like I'm having a patent on steroidal substances. So steroidal means they have a ring structure that has containing the cyclopentano, perhydrophenanthrene. So these compound, but all steroids have almost the same kind of structure. So if I'm covering such kind of product which is covering almost all compounds having this basic structure, this is a Marcus claim. So nobody else can use any other compound. Why? Because the structure is basically the same. So this is about the Marcus claim. So this is about like I'm through a single patent, I'm having a coverage on many similar structures, just prohibiting others from using any of the compounds. So I will have a patent on almost 10 compounds at once. So this is a case of Marcus claim. So this is about several species where applied and they were trying to get the patent. So plaintiff filed the suit for patent infringement of its CTPR patent, and defendant countered that patents are invalid because they are covered in a prior patent. Yeah. Plaintiff argued that though the species were covered, they did not form the part of the patent disclosure. How court dealt with that? So in a particular order, court said that they permitted the launch of the product pending to the suit and application for interim injection. So after hearing the parties, court came to the conclusion is that such a permission may not be granted, taking into consideration that damages from patent infringement are not always calculable. What damage has been done, it cannot be calculated. It is also pointed out that non-disclosure in a prior patent not to be fatal to subsequent patents, though they are covered in the earlier patent. So courts saw that they didn't see the need to permit the sale of the product in furtherance of the public interest. Okay. So they didn't allow to sell the product. And damages they didn't apply because damages are not calculable, but they just given like they didn't allow to sell the product further. So this is a case again of infringement about the Marcos claim. The defendant was saying that plaintiff have earlier used it. Why? Because the same compound was there, but court said that damages cannot be claimed. Only injunction means further they cannot sell the product. This was the decision. So you have to just summarize it in 2-3 sentences and can answer like this. Another was Sulphur Mills Limited versus Dharmaj Corp Guard Limited. So in this case, it was agricultural fertilizer composition. And Delhi High Court granted an interim injunction in favor of the patent holder. So Justice Pratibha Singh, this is a very landmark case actually. This was in news. Pratibha Singh rejected the defendant plea of prima facie patent invalidity based on a pre-existing patent of the patent holder. So actually, defendant was saying that patent holder has already a patent in the past and they are just using it. So they didn't allow it. So Justice Singh came to the prima facie conclusion that patented invention was novel, inventive, because it is used higher percentage of sulfur. Percentage it is changed and significantly changed, and small particulate size of the fertilizer compared to the prior patent of the holder. So there was addition of innovative features. She went deep inside that and found that it is better, innovative as compared to earlier ones. And that is the criteria for patentability. She also pointed out there is no teaching, suggestion, or motivation in the prior patent to arrive at the patented invention. This is also a point. So nothing was suggested in the earlier patent that this could be done. If it was there like a future scope or a further things, so it was not there actually. So she referred to the standard that patent should be granted. So as the defendant failed to make the prima facie case of invalidity, the court granted an interim injunction in favor of the plaintiff. Clear? So these are very simple things that you have to explain. They will not listen to you for any answer for more than 2 minutes. So try to summarize it in short. They just want to find out whether you know this or not. So just make them feel that you are already exercising this, you are capable of exercising the patents. So in this way, you can definitely manage it. Then Novartis versus Natco Pharma. This is also a new case. This is a pharmaceutical composition. Again, valsartan and sacubitril, along with pharmaceutical acceptable salt. It was held by Novartis. Novartis filed an infringement suit against Natco and sought an interim injunction during the pendency of the suit. Natco argued in the case that its supermolecular complex, which include valsartan, then sacubitril. So Natco argued in the case that supermolecular complex, which includes the valsartan, sacubitril solution, iron and water molecules, is not covered with the Novartis patent. And later application filed by Novartis with respect to the supermolecular complex excluded it from scope of the patent being asserted against Natco. What has happened? What court decided? Court rejected both the arguments and stated that Natco's complex is covered within the scope of the Novartis patent claim. While doing so, the court also rejected the opinion of the scientific advisor, which observed that Natco's supermolecular complex is not covered in the claim. It therefore granted an interim injunction in favor of the Novartis. So just you have to answer in the case. This was an infringement suit. This was about supermolecular complex between Natco and Novartis. Court granted an interim injunction in favor of Novartis. So these 3-4 sentences are enough for you to answer this, because they will not give you much time, as you are taking much time for answering a single question. Normally, the number of questions will be less. As I suggest, you try to attempt as many questions as they ask, because that will be a good practice. But if you are feeling, you can read their face. If they're uh, if they're like very concrete in finding out what do you know, they may ask you some lengthy questions. So in that case, do not shorten it, try to explain. But suppose if you're not very confident about it, at least you should manage it and stop it there. Whenever you know something, try to take your time. Whenever you have little bit confusion or not confident, try to wind it up and do not try to dig it much, because if you're not confident, and even if you are trying to just extend it, they will find that you are not very confident, you are not very knowledgeable about it. So just be very sure about the question, that are you able to answer perfectly or not. First of all, analyze yourself, then try to answer. If you are very confident, take 5 minutes. But if you're not confident, try to just answer it, so that at least you know that. So in this way, you can prepare. Let the results come. You can again ask me, you can again meet me. I will again give you some more advices just before your exams, so that you will be very fresh to answer the questions. So if you have any question, you please ask me.